Good afternoon. May it please the court, the Attorney General. It's my privilege to be here on behalf of Mr. Becker with respect to his sentencing. And I know that many of these issues of this case have been risen and have been determined before. However, I believe in my heart that it's one which should always be maintained and which should always be preserved, namely that the application of life without parole to the crime of capital sex battery is cruel and unusual punishment. In particular, Mr. Becker pled to, and I'm certainly not going to take the position that there's any such thing as a good or acceptable capital sex battery. They're all reprehensible acts and they're all awful, and no one's going to say anything different than that. However, I think when you apply this and consider the spectrum of offenses that could be under the umbrella of capital sex battery, even the very nature of the statute itself provides a number of alternatives. And then when you go beyond the statute and you consider that this offense can be contemplated with force and violence, with threats, with someone that's under custodial authority, or someone that has some other kind of control over the defendant, or it may not, then you see that the spectrum of conduct that is envisioned by this statute is indeed great. We made a motion during the pendency of this case to provide and to require the state to submit this to a grand jury, as the Constitution provides. With respect to Article 1, Section 15, does not distinguish, does not say in death penalty cases. We withdrew that motion in order to enter the plea and to accept the bargain of 30 years, which certainly is better than life without parole, but it's also very severe. And the problem that we have here is that we have an offense that the only way to plea bargain is to accept whatever terms the state has. And the problem is, and I think it's fair to raise at this point, is that even though we did withdraw the motion to require it to go to a grand jury, it's still fair to consider that this particular offense was determined back in 1982 or thereabouts, in the Buford case, I believe, and also Inman's, that it could no longer have the death penalty. We're no longer it wouldn't be proportional to apply the death penalty to these offenses. So in all these 33 years, the legislature has had repeated opportunities to amend the statute and say, okay, it's not a capital offense anymore, and they haven't done so. The Supreme Court of our state, and I certainly have the highest regard for them, but they have consistently stricken the procedural protections that are available to someone who is charged with this capital felony. And with respect to the language that's in Perez, I would urge this court and every court that has the occasion to consider a case brought under this statute to say that this is in reality a life felony, and it should be considered as such. If it were a life felony, Mr. Becker would have had the opportunity, if not being able to make an agreement with the state for an acceptable amount of time, he would have had the opportunity to ask for a departure hearing, enter an open plea, and present the court with all the mitigation evidence that existed. In this case, had a lot of mitigation evidence, starting with the nature of the offense and the way it was committed in this particular case.
Mr. Likes, your client, though, did not get a life sentence, correct?
He did not. He got 30 years.
So he pled to 30 years.
And yes, he pled to 30 years because that was his only choice of doing anything better than 30 years.
Your suggestion, though, is that the plea was not voluntary because of the coercive nature of the automatic sentence under the charged offense.
In effect, you could say that, Your Honor. You
haven't
could
said that in his brief.
No, but I mean, that's kind of where.
I haven't said that in the brief, and that's a different motion. And, you know, who knows, one day that might arise, but that'll be up to Mr. Becker. I told him, and he understood when he entered his plea that I would appeal this issue.
But that's kind of really the only way you get there, isn't it? Because he did not receive the life sentence, and so he is not subjected directly to a cruel and unusual sentence or a sentence that is disproportional. And you're saying the only reason he accepted the lesser sentence because it was in his best interest to avoid the possibility.
And none of his reasons for accepting the plea are anywhere in a record or a transcript. We don't have the benefit of any of that. We don't even have on the record some statement, he's only pleading to this, Your Honor, because there's nothing like that anywhere. So we really don't know why he pled to 30 years.
I will look. I will reserve 5 minutes, and I'll look. I think there was
All right,
minimum.
that'll be helpful to know if there's something like that.
Okay. I guess, Your Honor, there's a little bit of personal experience in these cases for me, is I've had a number of capital sex batteries in my career, and so many of these defendants are just recalcitrant, controlling, manipulative. This was a breath of fresh air, if there can be, with respect to this, because Mr. Becker freely admitted that. He freely admitted that he had a problem. He admitted to the conduct, and I certainly felt personally remiss that I couldn't get him a better deal than this, but that was the fact, and I felt like I was constrained to that because he couldn't plead without a deal, and he couldn't plead without going to the state and say, what do you have to offer? He couldn't. There was no opportunity for him to reach a judicial officer with
plead open and go to the court.
Plead open and go to the court. And I'll reserve the rest of my time. Thank you very much.
Thank you, Mr. Lights.
May it please the court, Cerise Taylor on behalf of the state of Florida. I'm going to go ahead and reference the record citation that I have. Counsel is volume 1, page 103. It's from the sentencing hearing, and he does talk about it being a best interest plea. And I'll let counsel talk.
But does he give anything more than just a best interest plea? Is there anything more?
I would consider that it seemed that the trial court took his time in making sure, because there was a question of competency that got raised, and ultimately it was determined that he is competent. And so the trial judge went the extra mile, I think, to say, make sure you understand that you're doing this. And at one point he says, I feel like I don't have a choice. And he says, no, you have a choice. If you're doing this in your best interest, if you think this is, as having talked to counsel, have you had enough time to talk to counsel? Yes, so we have.
But fairly reading it, and generally a best interest plea is in order to avoid the possibility of a higher punishment. That's
sure.
Generally why.
Sure, it's in your best interest. And I don't think that there's any authority for the suggestion that best interest plea then are inherently coercive, or that future best interest pleas would be found to be coercive by this court.
And I don't think that's what the argument is. I think it's given the nature of this allegedly disproportionate punishment, because the crime lumps together a wide range of behavior.
Mm-hmm. I think that counsel's been very candid, and this court really understands that we're talking about a very narrow issue here, that he would even have an opportunity to pursue an appeal, and it would have to be some appealable issue with regard to the sentence. Because the motion that objects to the capital nature of this cap sex battery was pursued and then abandoned upon the plea, at that point there's a waiver, and the only thing that he can appeal is his sentence. And also the trial judge, consistent with really the hand-holding, I think, that went on in a positive way, said, just so you understand, you can't appeal. If you decide this is in your best interest.
Procedurally, you can't bring a direct appeal.
Correct.
You might be able to do a Rule 3 based on involuntariness of the plea.
Right, and also the fact that and what the court specifically says is, if I gave you a sentence, if I imposed a sentence that was other than you negotiated, then you could go ahead and plea. And he recognized that, he understood that. And so really procedurally, that's where we're at. And if we don't have, we have a waiver of the substantive motion, and then we also have the issue of standing. This is not a case, as the court has recognized, where he received the death penalty. I'm sorry, receive a life sentence. And so, absent that, he doesn't have standing to object to the larger question of whether or not life imprisonment, the capital designation, is appropriate or not. But even still, just considered substantively, the decisions of this court, of the Florida Supreme Court, are longstanding and consistent. That the court recognizes that the legislature is continuing to keep a capital designation, but the effect of that designation does not entitle a defendant to the right to a 12-person jury, the right to indictment as opposed to information. And the judicial system, the legislative system, it's clear everybody understands that we've got two different almost uses for the word capital. The state submits that capital in the legislative sense is an expression of legislative intent to reflect that this is among the most heinous and serious of crime. And of course, prior to the Supreme Court determining that in cases of sexual battery, rape, that death penalty was not appropriate, Florida and Mississippi allowed death penalty when it was a capital sexual battery case. And so that expression of Florida's disgust for this grievous crime maintains itself in the legislative statements and also indicates the level of the offense. And so that applies itself to when we look at, well, in this case, we apply the attempted cap sex bat, and so we have a 30-year sentence. The courts have said that that's a lawful sentence because of this capital designation. The one step down is going to be a 30-year sentence, as opposed to it being a life felony, and the one step down being a 15-year sentence. So that designation doesn't make the fact that in our cap sex bat cases where you don't get those other benefits of a capital case, doesn't make it unlawful. This is a case, I think, where this court has seen many times, we have there's a range of sexual acts or activities that could arise under a broad designation. And we've heard people say, well, my sexual abuse of this child wasn't as bad as that sexual abuse, or it could have been, or someone else's, sort of a proportionality argument. But proportionality arguments are foreclosed under the legislative and the controlling authority from the Supreme Court. That proportionality analysis doesn't apply. And so whether or not it is less grievous to have oral copulation with a 9-year-old boy who'd had it happen before versus some other level of egregious, activity.
Well, or I think maybe the range that courts might be more concerned with would be threats, force, putting in fear, that's
sure,
or supervisory authority or whatever like that. That's familial authority.
I can understand that, and I can see where there might be cases where a court is faced with a more, like you said, custodial, that kind of thing. I can see where that would maybe tip the court's hand. But the fact that when you have any kind of copulation, any kind of union, penetration, the courts have said, the Supreme Court has said that it's enough. It's not disproportionate. And that kind of, because of the nature of the victim, that level of sexual conduct is unforgivable. We're not going to allow it to happen, and so we're going to have this life sentence. In Mr. Becker's case, he took the deliberate action voluntarily to enter a plea that even the trial judge notes he's not happy with it, as anybody would be unhappy with the prospect, 28-year-old man going to prison for 30 years. But it's the consequences of his criminal conduct. And the question is whether it was lawfully considered and whether he received the benefit of the governing laws and whether they are fair. And there's no indication that he received anything less than what he bargained for, or anything more than what he bargained for, and that the laws that govern it were applied correctly. And so in this situation, the capital nature of this offense, he really can't bring it up. But even if he was able to argue it before this court, it would not be a basis for appellate relief. Unless the court has any other questions, we'd ask that the conviction and the sentence be affirmed.
Thank you, Ms. Taylor.
I'm sorry, I don't have the one that's numbered the way the. But on the sentencing transcript at page 10, I did mention, I'm not sure that's what we're referring to, but I did mention that even though he was giving up his his right to appeal just about everything else, but he was going to file a cruel and unusual punishment appeal. And it was a very nice argument. And the fact that she said that there's no proportionality analysis is exactly why I'm saying it's a cruel and unusual punishment. We don't consider it. In the first-degree murder case, you have a dead body, and the dead body is there because someone intended it to be there, or because someone intended to commit one of the enumerated felonies that resulted in that dead body, and we still give that individual a jury to decide whether it's bad enough to warrant the death penalty or not. Here we have an offense that doesn't always have a dead body. It might not even have an injured body. It may have only an offended body. It may have a victim who goes on to live a completely normal life unaffected by this offense. Or it may result in some serious physical injury or psychological injury. We may have an offense that is committed with force and violence and threats and fear out of a relationship of custodial authority, a teacher, anything like that. And we have no difference between them. And, Your Honors, I would submit to you that that is prima facie cruel and unusual to submit the same person who commits the rather minimal on the scale of things. Again, I don't want to say that there's any good capital sex battery, but some are worse than others. And the fact that these defendants have no opportunity to provide a judicial forum with the opportunity to consider mitigation is one that I think makes it cruel and unusual. And I would point out the Supreme Court case of Solem, which talks about how you can have a proportionality analysis either between jurisdictions or within the same jurisdiction, provided that's with the same conduct. And I thank you all very much. Subject to your questions, I don't have anything further.
Thank you. Thank you, Mr. Likes.